Good evening from Los Angeles, California. I'm Dr. Ryan Ava. Out front tonight, the breaking news. Trump suffering two major legal blows. The first one, no more special master. A federal appeals court is stopping the special master's review of sensitive documents seized at Trump's home at Mar-a-Lago. And of course, you all remember it was a few months ago in September when the corrupt judge Eileen Cannon, who was appointed by Trump, sided with a disgraced single-term, twice impeached former president and appointed a special master, which of course at a time everything had to be reviewed, stretching this whole process out. The DOJ appealing, saying that the review and all this time would cause irreparable harm to their investigation. And the 11th Circuit Court tonight agreeing, slamming Cannon's decision. And let me just read a part of this here in the ruling. They say the law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant, nor can we write a rule that allows only former presidents to do so. Now, I just want to be clear here going through this whole thing, that the judges panel who wrote this ruling is made of judges nominated by the former President George W. Bush and, you guessed it, Donald Trump. So that's the first blow related to Mar-a-Lago, and it is significant. The other that matters a lot tonight too. It is regarding another federal criminal investigation, this one into Trump's efforts to overturn the 2020 election. Tonight, a federal judge ordering two attorneys to testify, Pat Cipollone, Trump's former White House counsel, and his deputy, Patrick Philbin, to come before the grand jury, basically rejecting Trump's claims of executive and attorney-client privilege. Both testimonies are crucial in the January 6 criminal investigation.
CNN Sarah Murray joins us now with more on this and the Cipollone case. So, Sarah, what does this mean, the court ruling on the Mar-a-Lago documents? What does it mean for the DOJ and their investigation?
Well, I mean, obviously, it's a big win for the Department of Justice, who had been arguing that there shouldn't have been a special master in this case all along. Practically, it could mean that they will get this whole mess of documents sooner than they would have otherwise. Remember, they already have access to the roughly 100 documents that were marked classified, but there were thousands of these other documents that they want to use to try to make their case about how things were stored haphazardly at Mar-a-Lago. So now they could get them sooner. Of course, the X factor is, will Trump appeal? We have seen his willingness to do so in many related cases. You know, he earlier appealed something to do with this case to the Supreme Court, and he may ultimately decide to go to the Supreme Court with this question as well. We should note, though, that this appeals court that ruled against the Trump team today, it is made up of 3 GOP-appointed judges, Anderson.
We mentioned Pat Cipollone's been ordered to give additional testimony before the grand jury investigating the efforts to interfere with the election. He already appeared back in September. It was obviously before the special counsel Jack Smith was appointed to oversee the DOJ criminal probe. What happens now?
Well, that's right. You know, what we have learned is that a judge ruled that Cipollone, as well as his deputy, Pat Philbin, had to go back to the grand jury and testify. Now, again, this is all happening behind closed doors. This is a secret court proceeding. And Trump's team had argued that because of privilege issues, that they shouldn't be able to answer certain questions for the grand jury. Now the question is, are these guys going to get swept into the grand jury quickly? Are they going to go there and answer questions? Or will Trump's team first appeal before they go back there? We do expect an appeal by the Trump team, so we're going to wait and see how this plays out. Again, this is all playing out behind closed doors, so we're learning this from people who have been briefed on the matter.
And just to be clear, this is the criminal grand jury probe for the Justice Department.
That's right. This is a criminal grand jury probe having to do with efforts to overturn the 2020 election. Remember, these guys were in the White House. They were around the former president. They were there when he was, raising schemes about trying to go to states, when he was, suggesting this potential coup at the Justice Department. So they have obviously seen a lot.
Carrie, how helpful, in your view, is this ruling to the Justice Department's investigation going forward?
I think the 11th Circuit ruling is important in the case. What it did is it basically said that the former president is not entitled to special treatment, that executing search warrants is a standard process for the Justice Department, for the FBI, when they're conducting an investigation, that when that warrant is based on probable cause and it's approved by a judge, that there really were no strong arguments made by the former president that a special master should be in place and that he should receive any special treatment. So I think the 11th Circuit case, in the opinion that was just issued, really resets this case in terms of the way things normally would work for any individual who is the subject of a search in any investigation around the country.
Ellie, how do you see the opinion?
Well, Anderson, first of all, this opinion is all about what we call jurisdiction, meaning the courts can't just do anything they feel like. And what the Court of Appeals today said is that the district court, in ordering the special master, went too far. That's not a thing that courts can do. You cannot interfere with a criminal investigation at this stage. And as a practical matter, what this does is it removes a roadblock or a speed bump for the Justice Department. It means that unless this case goes up to the Supreme Court and gets reversed, which I think is very, very unlikely, DOJ can now take all those documents that they seized at Mar-a-Lago and use them fully in their investigation. So it will enable DOJ to carry on with their investigation in a speedy manner.
David, just in terms of the legal strategy, do you think it was a mistake now for the former president's legal team to go through the route of requesting a special master, or if gumming up the works or slowing down the process was the goal, was that successful?
Yeah, so Anderson, I think we've had this discussion before. I think that the president has one idea and his legal team may have a separate idea, and he's the client. And I think they filed this suit, and facially they had a claim, and has been pointed out by the 11th Circuit. There's these three judges on the 11th Circuit. They don't really have the standing to do so for a variety of reasons, separation of powers and others. Look, I anticipate that the president's legal team will appeal and ask it to be heard en banc by the entire 11th Circuit, which likelihood of success there seems pretty slim. And then again, they'll appeal to the Supreme Court. I think that it's a tactic that we've seen before from the president's lawyers in terms of just delay. And I think that they'll continue to delay until the absolute last moment they can, and Supreme Court doesn't take it up. I don't think the Supreme Court will take it up, but they'll take it to the 11th Circuit on bank, and we'll see what they have to say.
And Kerry, how long could it slow things down? I mean, the ruling by the 11th Circuit doesn't go into effect for 7 days, which obviously gives the president time there.
Right, so it gives him time to appeal, and so then there'll be a determination whether or not the Justice Department can go ahead and actually look at the information. So there is, some, I think, a little bit of ambiguity as to whether or not they can start looking at the information right away, or whether or not they're going to have to wait a little while. I don't think there's any credible basis for the en banc appellate court or for the Supreme Court to take up the arguments in this case. And I think it's important to point out just how unusual the former president's arguments were in this case. The normal time that an individual would challenge the results of a search and say that their rights had been violated is when they've actually been charged with something. And so the former president, in his legal strategy, really jumped far forward here by trying to make arguments that his constitutional rights were being abused in some way by the way that the FBI handled this search. That just is not the way that normal investigations would work in any other matter.
To support my work, please subscribe to my channel and give this video a thumbs up. Also, please don't forget to hit the bell icon so you wouldn't miss any of my new videos. Thanks for watching.